Hey everyone, this is Seth Bloom, Senior Director of Attorney Services at LevelSet, and thanks for being with us today. I know things are a little chaotic out there with the coronavirus, and we just hope that everyone out there that's listening to us stays safe and is healthy. We're going to continue to educate all of our clients and our customers with bringing on great programming and webinars like we have today, terminations for convenience and project suspensions in the age of COVID-19. It's brought to us by Peter Lindbergh, and he's from the law firm of Lindbergh and Mazer from Glendale, California, and they service most of the Southern California, Los Angeles area, and I'll bet you can even get them up to Northern California if you need them.
You could do that.
So without further ado, Peter, thanks for coming on during all this chaos. I know we have a lot of people online right now. Wow, huge amount of participants, so I know we're gonna have a lot of questions, so have it away.
Okay, great, Seth. Thanks a lot. And glad to see you up and around. The idea for this seminar came to me where it should come from, which is direct from my clients, because in one 48-hour period, I had 3 separate clients tell me they'd gotten multiple either termination notices or suspension notices on projects on which they were working. And some of these guys have been around forever and had never seen one of these before and had no idea how to react to it. These are clauses in contracts which everybody ignores and hardly ever get invoked, but when they get invoked, it's a question of protecting your rights. So what I want to do today is go over 3 separate topics, kind of broadly speaking. Number 1 is just what are terminations for convenience and suspensions of work. Number 2, what are the factual and cost elements of each type of claim? Because when you get a termination for convenience notice, you have been given a claim. And sometimes, but not all the time, when you get a suspension of work notice, you've been given a claim. So we're going to talk about those things. And then we're going to get down kind of into the weeds a little bit and talk about how contractors make each kind of claim. All right? So turning first to terminations for convenience. What we want to do is say a termination for convenience is a decision by the owner to terminate all or a portion of the project. Now, this is not, I'll get down into the weeds a little bit here on the legal stuff, quote unquote. When you sign a contract, when Seth and I went into our first day of contracts law in law school, what we were taught is that when you sign a contract, you have an obligation to perform that contract. And if you don't perform that contract, it's called breach. That's fine, but pushing, well, what is this now? Pushing, during the Second World War, there were a lot of federal contracts going on. And when the war broke out, the government's priorities changed, and the government had no way to put a project either on hold or cancel a contract that it no longer wanted. So what the government did is it put in a termination for convenience provision. This is a pure creature of contract. There is no such thing as a common law or a statutory right in an owner to terminate a project for convenience. It's only there because it is in the contract. So what you have to do, the first thing you have to do when you get a termination for convenience notice in your contract is go to your contract. Find out what the rights of the owner are and what you have to do in terms of complying with that. The two most prevalent termination for convenience clauses, and we're going to be talking a lot about federal law because for two things. Number one, law on federal projects is very highly developed in this area. And number two, I know a lot of contractors out there on federal projects that are right now are getting termination for convenience notices and suspension notices. So we want to talk about that. The termination for convenience provision in federal law is found at the Federal Acquisition Regulations, and the numbers up there on the board. The second one is in the AIA A201 form. That is the typical set of general conditions under an AIA contract, which is obviously a fairly commonly used contract in private works. But you will find in probably 99% of construction contracts between a prime and an owner that there is some type of a termination for convenience clause written in there. There almost always are. It's become kind of an article of faith in our industry. And it's, like I said at the top, it's something that nobody ever pays attention to, but I bet you a whole lot of people are going to be paying attention to it now. Okay? The one proviso is in a termination for convenience, all termination for convenience clauses typically say that the owner can terminate for any reason at all or no reason at all. But if the owner is acting in bad faith, then that puts a limitation on invoking the termination for convenience clause. That's not going to happen here because with COVID-19 going on, there are lots of good and sufficient reasons to either suspend a project or to say, this project no longer makes economic sense. I'm going to terminate it halfway through. Okay? The other thing about termination for convenience clauses is that they're typically written so that they can apply to either all of the project or a portion of the project. We'll talk about that in a little while. Okay, what should you do when you get a termination for convenience notice? Okay, and literally you will get a letter that says, dear contractor or dear prime contractor from the owner is exercising its right to stop work and here's what you need to do, okay? So the first thing you do is stop, because any work that you do after you receive that termination for convenience notice, you're essentially doing it as a volunteer, okay? In other words, for free. So don't, okay? Stop work immediately. Second thing you have to do, call your lawyer, all right? And if the lawyer on the other end of the phone greets you with stone cold silence because he or she has no idea what you're talking about, call a different lawyer, all right? This is no time for somebody to learn on the job, okay? All right, like I said, termination for convenience is a creature of contract, so you have to analyze two things. Number one, what's the scope of the contract provision, okay? What does it say about the owner's right to stop work? What does it say about how much notice you have to be given? What does it say about the elements of a claim? Because a claim can vary or will vary by the termination for convenience provision. And we'll get to that in a second. Okay. Then the next thing you should do is you should notify all your subcontractors and suppliers because they've got to stop work. Okay. Now, this is where things get really interesting for you primes out there, because hopefully your lawyer has done a good job in your form subcontract, and there's something called the flow down provision in there, which basically says, if, among other things, is if it's not dealt with specifically in terms of this subcontract, then the provisions of the prime contract flow down into the subcontract so that the prime contractor has the exact same right to terminate all the subcontracts for convenience. under the exact same terms. And that's really important, because if you're terminating for convenience, if you're being terminated for convenience by the owner on the one side under a certain cost reimbursement formula, for instance, and you owe your subs on the other side for, let's just say, the contract value of the work that they have performed to date, you've probably got a dichotomy there in the amounts you're going to receive from the owner on the one side and the amounts you're going to have to pay out to subs on the other side, which becomes a problem. Okay? Like I said, must be settled in conformity with policies applicable to the prime contracts. All right, and then you need to assemble your claims and management team, because you've got a lot of work to do, okay? This is a situation when you get these notices, you are not without remedies, but you cannot sit on your rights here. You have to go about doing what is required, not only under the terms of the contract, but assembling your claim, okay? So let's take a look at those. All right. In a termination for convenience claim, like I've said, the contract provision defines what you can recover. For instance, and this is probably this is the federal rule. It's probably the most prevalent rule among all construction contracts, because a lot of people have adopted the federal model. What you've got, and I'm talking about, you're working on a typical hard dollar fixed price job, okay? When you are working on a project like that under the federal model and you get a termination for convenience notice, your fixed price contract has been automatically converted into a cost reimbursable contract, okay? Now, what does that mean? What it means is, under federal law, you are essentially going to recover on a termination for convenience claim all of the money that you have spent on this job, plus a reasonable markup, less the amount of payments you've already received. It's essentially, to my way of thinking at least, it's essentially the quote unquote fairest way to terminate a contract for convenience. In other words, you're going to be facing a situation where the contractor is going to recover everything he or she has spent on the project, plus a markup and less payments. Okay?
Hey, Peter.
And those costs can include pre-construction costs. I've got one client right now. We have a claim on a termination for convenience where the termination notice was issued between notice of award and prior to notice to proceed. But the client had already spent about $75,000 just doing, pre-NTP work, ordering, scheduling, et cetera, et cetera, et cetera. So you can include those types of pre-construction costs in your claim. In other contracts, however, you sometimes, as I've mentioned previously, the termination for convenience is based not on the costs incurred by the contractor, but on the value, quote unquote, whatever that means, received. And typically what that means is, if you're working on a schedule of values, then you get what the contract has assigned to the work you have accomplished thus far. Okay? Subcontractor claims. Okay? So, one of the first things you have to do as a prime contractor, like I said, is notify your subs, tell them to stop work, and tell your subs to start putting their claims together. They're going to have lots of questions, so you're going to have to walk them through this kind of a process and what it is you need. But you need to gather up all of those subcontractor claims.
Peter, if I can
The
stop
next
you for a
type
second.
of
Can you hear me,
element.
Peter?
What?
Can you hear me? We had a question come up.
Sure,
So
go ahead, Seth.
yeah, sorry. I know there's a little bit of a delay, but Debbie asked, can the subcontractor who supplies the material still file their liens then?
Yeah, you can secure a claim with a lien. There's no doubt about that. So you still have your rights. Now, what your claim may be worth is one issue, but there's no doubt that you can secure that claim with a lien at that stage of the game. So the next element of a termination for convenience claim would be things like rental and restocking charges. You know, a lot of times when you get a termination for convenience notice, you've got equipment that's rented and you've got a rental agreement that requires X amount of days fixed, and you can't cancel that. You can't cancel that lease. Those types of charges that you have to pay. When you return materials to a supply house, a lot of supply houses charge you restocking charges. You get to add those to your termination for convenience claim. You can do demobilization and site protection costs. Not only do you have just the cost of demobilizing, but in a lot of projects, you have some pretty valuable stuff that the owner wants secured in one way or another. So the costs of protecting that type of equipment or the rest of the project or whatever it is can get added to the claim. This is important, all right? This is in a lot of cases the one place where you get to add your claim preparation costs. That's your outside professionals, that's your lawyers, that's your accountants, that's your own staff time in assembling this claim, all get to be elements of the claim in most cases. And you get your overhead and profit, like I said. So sometimes the overhead and profit is defined in the contract. Sometimes it's whatever your overhead and profit rate was for the job in and of itself. And then on the AIA form, if you're lucky enough to get terminated for convenience on an AIA contract, the AIA form says you not only get a markup on what you've spent, you get to recover the profit and the overhead on the unperformed portion of the work. It's pretty hard to lose money when you're getting paid your overhead and your profit on work you didn't do. And then, like I said, you just subtract out the bottom the previous payments. So if you stack up all of these types of charges, that's the amount of a termination for convenience claim. In a partial termination for convenience, you have to not only look at what is being terminated, but also the portion of the project that's still going on. Are there increased costs on your performance of the remaining work? Do you have, for instance, unabsorbed overhead? Have you encountered delay costs? Have you got other kinds of impact costs in terms of losses of efficiency? Okay, then you have to look at whether subcontracts for the portion of the work that's still going to be performed, can they be assigned in the event of a termination for convenience? And under what terms? For instance, the AIA 201 only provides for assignment of subcontracts in a termination for default, not in a termination for convenience situation. And if there is an assignment provision, then the contract should, hopefully, spell out what the general contractor will receive for the costs incurred already for those subcontracts that are going to be assigned. Okay? Now, submitting a termination for convenience claim. Again, we're going to default to the federal model. So unless you're in on a federal project, there's no specific form. if you're on a federal project, the typical form for submitting these, and you can look these up online, but they're forms SF 143604A, that's the primary form. And the following form is essentially information about how you keep your books, because these claims typically do get audited, because remember, you're converting a fixed priced hard dollar contract now to a cost reimbursable contract. Okay? And the other thing you need to know, at least on a federal project, is that termination for convenience claims have to be submitted within 1 year of the date of the notice of termination. Okay, let's go to suspensions for work before we run out of time. Suspension for work is a decision or action by the owner which suspends work on all or a portion of the project. This is not a termination. It's not like we're done now, we don't want to play anymore. It's just we're going to be taking a pause. All right? This can be ordered by the government pursuant to the federal acquisition regulations, for instance, on a federal project. But there are typically, again, in all construction contracts, suspension of work provisions. And unlike a termination for convenience, which can only be done by notice, a suspension of work can also happen constructively. That is, essentially, the owner is suspending the work without telling you it's being suspended. If it's done constructively, then the contractor has to deal with this just like it's any other kind of request for a change or a claim. In other words, you have to give the owner whatever notice is required by the terms of the contract. And the suspension can be for either a definite or an indefinite period of time. Some suspension notices that I've seen over the last couple of weeks say 60 days. Others say indefinite. And so you don't know when the government may start up work again. Okay, let's talk about examples of types of things that can lead to a constructive suspension. And this is essentially the same type of list that you would see in the case of any other type of a delay claim. An unreasonable delay in making the site available, a failure to make timely progress payments, a delay in investigating contractors' request for a change or a time extension, an unreasonable delay in returning submittals or shop drawings, a failure to furnish owner-supplied materials, errors or omissions in the plans and specifications, improper rejection of progress payment requests, issuance of numerous change orders, failure to respond to RFIs or make decisions within a reasonable time, and a failure to make proper and timely inspections. Okay, the thing you've got to be cognizant of here is that in a suspension claim, the suspension must be unreasonable for it to be compensable. Okay, so it's kind of the same notion that you go through whenever you encounter a delay of any type on the project. Is it an excusable versus an inexcusable delay? If it's an inexcusable delay, in other words, contractor's fault, nobody's going to get anything, either time or money. If it's excusable, then the next question becomes, is it compensable versus non-compensable delay? Okay. In other words, am I not only going to get time for this, but am I going to get paid for this? Okay. So when we've been talking about unreasonable suspensions of time, what we're talking about is something that's ipso facto a compensable suspension. You know, a compensable suspension and an unreasonable suspension. Okay. You got to make sure that there's no concurrent delay on the job that's already holding up the job, because if there is, then you're not going to get compensated. You may get time, but you won't get money. And like I said before, the suspension has to be unreasonable given the facts and circumstances of the project. What does that mean? Well, let's just say, for instance, you get a 60-day suspension notice on a 4-year-long project that you're in, say, year 2 of right now. And there is 90 days float built into the project schedule as it currently sits. Well, if the owner is putting the project on pause for 60 days when there's 90 days to give, that's probably not going to be an unreasonable suspension. All right. On the other hand, if you're working on a 4-month project and you get a 60-day suspension notice, I'm going to bet that that claim is probably going to be deemed to be an unreasonable suspension of time given the facts and circumstances of the project. Okay. All right. So, like you said, you got to decide first whether it's excusable versus an inexcusable delay. And an excusable delay entitles a contractor to extension of time, but not necessarily to increase compensation. And an excusable delay is not usually foreseen and not the fault of either party. Now, I will tell you that there are a lot of owners taking the attitude right now on project suspension claims that these suspensions may entitle their contractors to time but not money because this is a result of unforeseen events. I think that that's a little facile. And again, I think you have to look at the facts and circumstances of each particular project. Okay, but I will tell you that that a lot of owners are now taking the attitude that this is an unforeseen force, and therefore it may entitle contractors to time, but not additional compensation. Okay, if you do have an unreasonable suspension of time or suspension of work, then what are your cost elements? This is like any other delay claim. All right, you've got your extended direct job expenses, salaries for foremen, superintendents, blah, 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 blah. Equipment standby costs, additional local office expenses, trailer, phone, utilities, et cetera, et cetera. Increased material costs or labor wages or other expenses due to escalating prices. If you're on a project that gets delayed or gets suspended and your material costs or labor costs go up in the interim, that could be an element of your claim. You got additional insurance costs because of the extra time. I mean, insurance is a time-driven cost. You might have additional bond premium expenses. And particularly in the case of an indefinite suspension on a project, if you've got one of those, you may have the right to claim for extended home office overhead. I won't go into the Eichle formula because that's an entirely different webinar as to how home office overhead is calculated. But if you've got an indefinite suspension on a given project, you may have the right to claim home office overhead in your suspension of work claim. And you submit a suspension of work claim just as you submit any other request for a change order, okay? You've given your notices, you've assembled your costs, you send the client, whether it's sub to prime or prime to owner, you send them a request for a change. And that's it. I think we made it.
Yep. That was great. And in fact, you gave us a minute or two for some questions. So
Okay.
That will be good. Someone had asked about the PowerPoint presentation, and we'll make it available to you. I'm not sure exactly how that'll happen, but we will do it. So Elizabeth had asked, we haven't received any termination notices, but we do have several jobs that have suspended due to the shelter-in-place orders in our area. is there a way to make a claim for our expenditures on these jobs?
I would say the answer to that may very well be yes. I mean, you you may be incurring costs that you would not otherwise incur. You may have had to demobilize from the job, and when the job starts back up, you may have to remobilize. That's two extra sets of those expenses. You may have additional security expenses on the job, keeping it safe while the project is suspended. You could have other sets of costs depending on how long the suspension goes on. So yeah, if it's additional sets of costs resulting from a suspension, I would say at least when in doubt, make the claim.
Okay, and I have one more question here. If I submit my claim as a subcontractor, but the general contractor doesn't send to owner, what are my options?
Well, it's a pretty brave contract, a pretty brave general contractor. Uh, but your contract right there is clearly against the prime contractor. If the prime contractor chooses not to send your claim on, then the prime contractor tends to own that claim. And again, just like we said in response to the first question, you've still got your standard job rights, depending on what kind of job you're on, to secure that claim in terms of bond or lien or whatever.
Peter, I have a question. It's a little bit more general. Like we're level sets down here in New Orleans, and we've been hit pretty hard with COVID, a little bit less than we're a hot spot over Southern California. So, but I have noticed that we, in certain governmental briefings, that construction is an essential service. So when I walk around my neighborhood alone to get my walk in per day, I see construction going on. I see cranes moving. So how are people justifying these suspensions when construction is still allowed with some of these precautions? Is that state by state? Is that, kind of how is that working, and how will that affect litigation in the future?
That's a really good question. Yeah, it's very hard, and I think that this goes back to that one section we were talking about where we said the owners are taking the attitude that this may entitle contractors to time but not money. If construction is an essential industry, and it has been designated as such in most regions of the country that I know of, it's a little hard to use the coronavirus as an excuse to suspend the work. So I don't think, again, that's going to get the owners out from underneath claims for additional compensation based on that. Now, I have heard, at least in certain places, that residential construction may be deemed or is starting to be accepted from the essential construction services, but that tends to be in fairly isolated areas.
Well, we've made this a 30-minute webinar. I know this is probably worth an hour and a half, especially since I just saw we had 11 more questions come in. But, so I'm sorry to there's some, to Tina and Megan and Tina and Jay and Newell and Nicole and Melody. I'm glad you liked my question. But, again, Peter, thank you so much for coming on. I think
you got it. And if anybody's got any questions, they can get me, my email's up there, or they can get me direct, or they can get me through LevelSet.
Absolutely. And Peter, once again, thank you so much for doing this. I'm Seth Bloom. I'm Senior Director of Attorney Services at LevelSet. Send me an email if you have any questions. We can help get your questions answered by wonderful attorneys like Peter, who's located in Southern California and services most of the California area. They're in Glendale. I've been to their offices. I've met with all the partners. So
Yes,
this is the real deal. They're vetted out. These are construction people that really know what they're doing. So, and that's what we try to pride ourselves in the Expert Center, is really getting the best people in every part of the country. So Peter, again, thank you. Everyone stay safe. Please post those questions on the Expert Center. I'm sure Peter will answer a few more today. And if not, some other lawyers can help him out. Have a great day. And thank you so much.
Good to see you as always, Seth. Stay safe.
Thank you.